The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm Adam Shelton, filling in for your regular host, Anthony Sanders. We're recording this on Monday, August 23rd. If you enjoy this podcast, take a look at our newsletter, an often irreverent take on recent Court of Appeals decisions, which we send out every Friday, and check out our sister podcast, Bound by Oath, a documentary series that this season is focusing on all things immunity and accountability. And if you're in the DC area, come join us on September 10th at George Mason University for a conference. If you like political science, economics, and legal theory, then this event is for you. We will be discussing the concept of the will of the people and its relationship to judicial review. You can find the link for the conference in the show notes. This week, I'm joined by two returning guests, IJ attorneys Patrick Giacomo and Andrew Ward. Welcome back, gentlemen.
Hey, Adam. Thanks for having us.
Thank you. Thank you very much.
This week, we'll be discussing a Ninth Circuit case, Ford v. Perry, about the Anti-Terrorism and Effective Death Penalty Act, and one not so respectful dissent. And a case from the Third Circuit, Drummond v. Robinson Township, about zoning in a gun club with some judicial engagement-y language. We're going to start it off in the Third Circuit. So, Andrew, did the town really change its zoning code just to prevent this gun club from fully reopening as it intended?
Well, that's what's alleged. Ultimately, the panel decides it doesn't really matter because we're not going to focus on intent in a facial challenge. But probably we'll see what discovery reveals. But this is Drummond versus Robinson Township. And just even before the subject matter, this is an extremely well-written opinion. It's out of the Third Circuit. It's by Judge Krause. And it's just sort of a great guide. Like, it's a very casebook type opinion. It's a great guide to sort of how modern constitutional litigation works under a form of heightened scrutiny. And you can really see the panel just marching through here's how we decide these issues, here's what we do, here's how the pleading standards work. And you can, I don't know, I sort of imagine this getting put into a con law casebook as I was reading it, because it's a very just good, direct, clear opinion. And what it's about is the Greater Pittsburgh Gun Club, which is in the defendant, Robinson Township, which is a little township about 12 miles west of Pittsburgh. And the township does not seem to want the gun club to operate. So it's been there for almost a century in one form or another. The National Guard practices shooting there, but the town doesn't like it. So in the 90s, there was some sort of nuisance action that maybe they tried to shut it down. In the 2000s, they arrested the owner. I mean, not them, but the owner was arrested for being a felon in possession. Not Mr. Drummond. It doesn't seem to be. It seems to be the prior owner. And the thing just shuts down. But eventually, Mr. Drummond buys this thing, and he's planning to reopen it in 2017. And the town, again, just doesn't seem to like it. There are citizen complaints, and they go and they see if they can zone it away. Maybe they just changed their zoning code for entirely unrelated reasons. So they what they do is two separate things. So they change the rules for sportsmen's clubs, which is what the Greater Pittsburgh Gun Club is, and they say two different things. One is that sportsmen's clubs can only use a certain kind of ammunition, rim fire, as opposed to center fire, and without getting too technical. That's just where the primer is in the round, but basically it means smaller caliber rounds as opposed to bigger ones. And the other is that sportsmen's clubs have to be nonprofits. Both of these are going to put the Greater Pittsburgh Gun Club out of existence. So Mr. Drummond goes. He gets Alan Gura, who's actually probably the most well-known Second Amendment litigator in the United States these days, who litigated the major Second Amendment decision, DC versus Heller, and they sue. They bring a lot of different claims, but primarily, this case is about the Second Amendment on a motion to dismiss. It goes up and down and up, and it's in the Third Circuit, and the Third Circuit ultimately says these restrictions on the pleadings are not going to survive intermediate scrutiny. And how do they get there? Going through the sort of standard historical originalist sort of analysis that you see in modern Second Amendment law. So referring to Heller, which is the major case in this area that Justice Scalia wrote back in the 2000s, they say we need to do a historical analysis. So first, you look and see if the regulation is the sort of historical thing that could pass muster just based on history. So like a restriction on felons possessing firearms, for example, is a good example of that. But here they say there's no real historical analog. It's interesting balancing the sort of level of generality, and they talk about this because they say, if it's way too specific, there are going to be no historical analogs because it's centuries later. Nothing is going to be analogous if you're looking too specifically. Of course, in 1789, there aren't going to be laws about AR-15s or something. But at the same time, if it's too broad, then everything will have a historical analog. If it's the level of, were there restrictions on firearms, then the answer is yes. So they go and sort of balance what's the right level of generality. And they talk about restrictions on common weapons that are otherwise permitted. And basically, they don't find any historical analogs for either of these things. There's really nothing on common weapons that aren't abnormally dangerous. The closest thing is maybe having too much gunpowder in one place, and they don't see that as analogous. They also talk about just being totally unable to find anything about who could own and sell guns, whether it has to be a nonprofit entity as opposed to a for-profit. The closest thing they have there is something on who could buy guns that slaves, for example, were not allowed to, and they say that's nothing like this. So they say there isn't a historical analog. This isn't grounded in history, which means it needs to survive, and this is the second part of the analysis, some form of heightened scrutiny. So that leads to the question of whether it should be intermediate scrutiny or whether it should be strict scrutiny or maybe a very exacting form of intermediate scrutiny. The levels of scrutiny keep multiplying in the courts of appeals. But ultimately, they decide that intermediate, substantially tailored to an important government interest is the right level. This doesn't strike at the very core of the Second Amendment, which is the idea of self-defense in the home. This is being able to practice using firearms outside the home. And they say that that's not really the heartland. It's not strict scrutiny, but it's because it doesn't have historical analogs. The Second Amendment's an enumerated right, so it's still going to get some form of intermediate scrutiny. And after that, they basically reject everything because this is a motion to dismiss. It's on the pleadings, and of course, there's just zero evidence in the complaint that the plaintiffs drafted that this is going to be able to survive intermediate scrutiny. They talk about there not being less restrictive means. There's no evidence that the township looked at something less restrictive or had other ways to deal with these things. Maybe it's enough if they just follow normal safety rules. This is a total outlier. And in fact, Robinson Township didn't change the zoning for shooting ranges. It only changed them for sportsmen's clubs, which is very much suggesting that this is suspiciously under-inclusive. So on the pleadings, there's a totally valid claim, and it's going to go back down to get litigated. They declined to issue a preliminary injunction in the first instance. They leave that for the district court. They also deny Mr. Drummond's request to get a new judge, pointing out that, just because he ruled against you in a complicated area of constitutional law does not mean he's actually biased against you. You can go back and have the same judge. But it is a big win for Drummond and for the Second Amendment more broadly. The thing that I think is most interesting about it, besides that we're seeing this precedent really develop in real time because the Second Amendment protecting an individual right to bear arms has only meaningfully existed since Heller in the 2000s, and watching that evolve is pretty interesting. But the thing that I see in it as an IJ attorney, and I think I've said this maybe every time I've been on this podcast, but it just shows so much how standards of review matter. This is an enumerated right. It is a favored protection. It's in the Bill of Rights by name, not in the Ninth Amendment. And so the court cares about it. They say, of course, you win on a motion to dismiss. We're going to take the pleading standards seriously. There is no evidence here that you don't win. And of course you went under intermediate scrutiny on the pleadings. And I just contrast that with IJ often litigates under the rational basis test, which is the lower form. And there, the result would be completely different. I mean, you can posit an identical thing. What about a golf course or like batting cages? These are, also places where people to go to have fun with projectiles. But if the township said some equally possibly silly thing of like, well, golf balls could be dangerous. They could hit the cars that are passing by, or they could distract people. People yelling "for" is noisy. Yeah, the court may well uphold that on a motion to dismiss because it's a different test. They might say, well, sure, we can imagine that happening, but as long as they're under sort of real review, no way on a motion to dismiss. And so that is what I take away from this. Besides evolving Second Amendment jurisprudence, is that pleading standards and substantive review standards really, really matter.
Patrick, any thoughts?
Yeah, I mean, if we keep it inside of the fun with projectiles analysis that Andrew is talking about, I shared the same observation, which is, we don't know what's going on here. Is this truly an anti-gun thing, or is this more of just a NIMBY or protectionist thing? And we'll find that out as discovery proceeds. And so I think the court's right to have allowed the case to move forward. And as Andrew points out, this is in such stark contrast to the way we see things that IJ normally litigates in the rational basis context. And I think that the most stark example of that is here. One of the two things that the township did was prohibit for-profit entities from running sportsmen's clubs, which I'm still kind of scratching my head to figure out what was actually behind that, other than, hey, man, we really need to think of some reason we can keep this place from opening. And apparently, based on the discussion the court has, there was some weirdly phrased aspect of the for-profit side of it that suggested there would be more people doing it, or there would be a higher intensity of people doing it, which I don't understand how that follows. I've personally been to nonprofit and for-profit places where you can shoot guns, and I didn't notice there being a correlation between whether the ownership was allowed to have profit from what was happening or not, and the intensity of the behavior at the place.
I think it's that this guy is for-profit. NGIMBY, it's no guns in my backyard. I just invented a new acronym. I think it's because this guy's for profit. But we'll see. We'll see in discovery.
Right. And I think you're right. It'll end up being some crossover of these two, strange bedfellow situation where you have the people who want to, make the selling and shooting of guns more difficult, and the people who just don't want to have whatever in their backyard. In this case happens to be a gun range. And, there's a lot of good reasons why you might feel that way selfishly, but not any good reasons why you should be allowed to use zoning law to prohibit these things just because, oops, you realized after the fact, like there's something coming that I don't like. And thankfully, as Andrew points out, because we're dealing with higher levels of scrutiny, that doesn't fly, at least at this stage in the case. But if this were a rational basis case, you could see it going exactly the opposite way. And the searching review that the court does to do historical analysis and decide whether the Second Amendment prohibits this type of thing would it be inverted, and instead you could see the court doing a searching review of any possible reason why these fun projectiles should not be allowed to be shot off in the greater Pittsburgh area.
Batting cages are noisy, Patrick. The bat hits a ball, the same way around goes. That's a lot of noise. You can't, there's a rational basis.
Well, just think of the soundtrack, too, at the batting cage. You're talking about like music from the late 90s, early 2000s blaring loudly, the smell of pizza. Who knows what else could be going on that would be a nuisance to surrounding areas. So
that sounds rationally related to a legitimate state interest. That's what I'm hearing.
And Andrew, did you have any thoughts about kind of the way the Third Circuit here analogized Second Amendment law to First Amendment law and kind of First Amendment principles?
Yeah, that's something that comes out of Heller, and I think it makes a lot of sense. I think it makes sense just in the fact that ideally, constitutional law should be coherent, and you should be able to sort of treat rights the same way and treat limitations on government power in one way. It ideally things would just be consistent, and if you want to do something that you have a right to do, we would analyze that in one way. So I like the analogizing. I think it's good for the development of con law.
Well, we'll keep our eye on this case. So, Patrick, turning to the Ninth Circuit, what in the world is binding dicta?
Well, we're going to get to that, but it's going to be a little bit of a bumpy road before we get there. So just bear with me, people. So this case is called Ford versus Peary, and it's a habeas review case, which means that it's a situation where somebody has been convicted of a crime and is challenging the constitutionality of that conviction in federal court. So let's start at the very beginning here. And our petitioner for habeas review is Keith Ford. Keith Ford was convicted of murder in California State Court. And at the closing of his case, the prosecutor giving his closing remarks, which are not evidence, but are provided to the jury in very blustery fashion, ended with the statement, "The idea of the presumption of innocence is over. Mr. Ford had a fair trial. He's not presumed innocent anymore." Now, that's legally incorrect, but this statement was made at the end of a long explanation where the prosecutor over and over said he had the burden of proof. And essentially, I think this was a very clumsy way of the prosecutor trying to say that he'd met his burden of proof beyond a reasonable doubt. And so the jury should no longer think of the petitioner, Mr. Ford, as being innocent. But anyway, that's where things ended. And at the time, Mr. Ford's attorney objected to that statement, and the judge in the criminal case overruled that objection right before Mr. Ford was convicted of murder. And then he appealed that decision to the California Court of Appeals, which in relevant part said, we're going to assume that what the prosecutor said was a misstatement of law. Nevertheless, there's no harm, meaning what he said didn't actually affect the outcome of this case, and therefore the conviction was sustained. The California Supreme Court didn't take the case at all. And then Mr. Ford moved for habeas review in federal court. Eventually, the case made its way to the Ninth Circuit. And here's where things get interesting. So for habeas review, since we're talking about the mischief that can be created through standards of review, we're dealing with a statute that Congress passed called the Anti-Terrorism and Effective Death Penalty Act, which greatly restricts the availability of habeas relief. And what it does in this context is it says that federal courts can only grant habeas relief when a state court's decision is unreasonable in its application of clearly established law as announced by the Supreme Court. So call back to our immunity work. Clearly established law is a phrase we've seen in the qualified immunity space that makes it very difficult for plaintiffs to sue government officials who violate the Constitution. Well, this has a similar effect in that it allows there to be constitutional violations that keep people in prison because Congress has said only unreasonable, first of all, violations and only violations of clearly established law as determined by the Supreme Court. So essentially, if there's not a Supreme Court case on point, and even if there is, if reasonable jurists could disagree on how that would apply in the case, you can't get habeas relief. Therefore, you have to stay in prison even if your constitutional rights are violated. So that's the background standard that we're dealing with. A lot of judges in the Ninth Circuit don't like the ADPA, and I share their dislike, but they're the ones that have to apply it, and I don't. I can just take shots at it from the perspective of a civil rights litigator, which I love doing. And in this case, there's a three-judge panel in the Ninth Circuit, and they issue an opinion, and they say the prosecutor's statement here was misconduct, and that misconduct did affect the outcome of the trial, and so there is habeas relief here. He gets a new trial. Well, the state moved for rehearing of that decision, and then before it got to that point, en banc, the panel withdrew its opinion, wrote a different opinion, and this time said, actually, we do have to defer to the state courts here, and when we do that, we think it's a close call, but because of the ADPA deference standards, we cannot grant review to this case. Mr. Ford has to stay in jail. But along the way, it also said, weirdly, in my opinion, here, the California Court of Appeals said that we're going to assume the prosecutor had made a misstatement of law when he said that the presumption of innocence no longer applied. But if it didn't, here's how we would have analyzed it. And then it goes through its analysis. And then it does a similar thing when it deals with the prejudice, the amount of harm analysis. It says, well, we're focused on ADPA deference, but if we were reviewing this de novo, it would come out a different way. And so in these two passages of dicta, the Ninth Circuit basically says, well, if it went the other way and if we could review this the way we think we should through de novo review instead of through this deference review that the ADPA allows, it would have come out another way. Mr. Ford would have gotten a new trial. Well, after that's done, one judge on the Ninth Circuit, sua sponte, calls for a poll for en banc review, and that judge is Judge Lawrence Van Dyke. He doesn't get anyone to vote for en banc review, so he dissents from the denial of en banc review in a very fiery way. And there's a lot of colorful language in this case. He basically says at multiple points. At one point, he says that this is like a kid getting caught with his hand in the cookie jar and then spitting into the cookie jar in like a moment of insolence. And he has a lot of other little flourishes like that along the way. And his point here is twofold. So one, he at least evinces some amount of approval of the ADPA standards. And so he goes through and he says, I think most egregiously, here, there's no case that even necessarily from the Supreme Court's perspective says that a prosecutor telling a jury that there's no presumption of innocence is a clearly wrong statement of law. And therefore, in his opinion, there would never be any basis for a reversal on habeas grounds of something like this. But I think the more important takeaway here is what Judge Van Dyke is driving at is what he calls the binding dicta rule. And so the Ninth Circuit has a rule that it calls the well-reasoned dicta rule. And under this rule, the Ninth Circuit says, well, if a case has dicta, which to our non-lawyer listeners is language in a court opinion that's not necessary to its decision. So if a court says, we decide this based on X, but by the way, Y is important because of this other reason. X is the holding, but Y is the dicta. And in future cases, X is binding, but Y is not. It may be persuasive. Well, the Ninth Circuit takes a different approach. And it says if the dicta is well-reasoned, whatever that means, then it is actually binding on future panels of the Ninth Circuit. And this is very strange. I did a little bit of extra research on this morning, and there are at least a handful of other states that apply a similar rule that is kind of like, well, if the issue is before us, or if we really give the issue a close look, then it is actually binding, even if it's dicta in the case, which is odd and allows for quite a bit of mischief, which is what Judge Van Dyke's point is here. He's saying, look, because we have this binding dicta rule, the outcome of this case was ultimately this panel changed its mind and said that habeas does not apply in this case. But then it goes on this hypothetical frolic where it says, if the state court had done this and if we were deciding this under different standards, this is what the law should be. And his theory here is that what the panel is doing there is trying to set up a future panel to be able to grab that and say, well, this is well-reasoned dicta, therefore it is binding in this case, whatever the case will be, presumably another case involving a prosecutor pushing the limits of what he can say as far as the legal standards in a criminal case. And then, Bob's your uncle. You have new case law that's just been resurrected from this case. And as Judge Van Dyke also points out, because here ultimately the panel reversed and held that there wasn't habeas review, there's not really any party who's able to challenge its use of dicta in this case, and therefore there's not any party that's able to challenge its future use under this well-reasoned, as Judge Van Dyke calls it, binding dicta rule in the Ninth Circuit. And so I think I disagree in almost every respect with Judge Van Dyke's discussion of the ADPA as far as its substance, but I think that he's definitely pointing out something that is a problem with this well-binding dicta rule, because you can see all sorts of nefarious uses for it. And the Fifth Circuit actually has some similar rules. They're kind of different. So the Fifth Circuit has a rule of orderliness and a rule that alternative holdings are binding to future panels. And so you can have decisions in the Ninth Circuit that just go off on any issue that may or may not be before the court that certainly doesn't have to be dispositive, and then that can become binding in future cases. And the Fifth Circuit has rules where you can say, well, we're deciding this case on this basis, but alternatively, we could decide it on this basis, and then going forward, that alternative ruling is binding to future panels. And so unless the courts are going to take a much more robust approach to doing en banc review in any cases, these are problems that are very difficult to solve, because the best you can hope for is something like Judge Van Dyke's dissent from the en banc denial here, since the parties are almost never going to be able to challenge those rules. And the Supreme Court's very likely not going to be interested in granting cert to address something as esoteric as, the way the Ninth Circuit's dicta rules operate.
So, Andrew, what do you think about binding dicta? Putting aside all the colorfulness of Judge Van Dyke's opinion, who I'm not sure I ever want to be on his bad side necessarily after seeing that opinion, but what do you think about binding dicta?
Well, I don't know how often this happens on the podcast, but I think I lightly disagree with Patrick on sort of both sides of this. As first on the substantive ruling, Judge Van Dyke points out that it's not like the prosecutor got up in front of the jury and just said, there is no presumption of innocence. These were sort of inarticulate statements sandwiched between repeated reminders that there is a presumption of innocence, including in the judge's jury instructions after the prosecutor had summed up. It's not. I tend to agree. The due process standard here is that it's supposed to so clearly infect the trial that there's a real chance of a miscarriage of justice, and it's not obvious to me that these sort of stray things were that. And I tend to kind of be sympathetic to Judge Van Dyke on that. But on the binding dicta thing, I don't know that I can ignore the tone of the dissent. It does seem perhaps out of proportion to the panel opinion. I looked at it, and it's not like some lark into the First Amendment in a case about whatever zoning law. If it were totally unwarranted in that, it's like pretty short. It's just kind of, here's what we might do. I wouldn't write an opinion that way. Chief Justice Roberts once wrote something that was like, if it is not necessary to decide more, it is necessary not to decide more. And I probably wouldn't have phrased things the way the panel did, but it doesn't seem so egregious as to warrant being called sinister by the dissent here. And actually, without but the potential is there, right? Certainly, I think alternative holdings being binding seems to happen in many courts, and certainly the rule's subject to manipulation. It's not clear to me that the panel was doing what Judge Van Dyke was accusing the panel of doing. More broadly, I think this is perhaps most interesting tonally, as opposed to the actual substantive issues. It really exemplifies the trend of judges trying to make their writing more casual, more punchy. Judge Newsom in the 11th Circuit does that a lot. Judge Van Dyke's here, one sentence weird comment reminded me a lot of then Judge Kavanaugh in the DC Circuit writing a one sentence thing like that, where it was sort of like the state's response, crickets. And so that tone is something we're seeing more and more of with sort of a new generation of younger judges, and it's interesting. And as the dissent writes, shout out to the law clerk. There's a footnote in here that says, I had my law clerk compile all the times we got reversed for screwing up the deference standard, but it was too long, and so it felt too mean. It was like beating up a career criminal with a super long rap sheet. And I feel you, clerk, out there in the world. If you ever listen to this podcast, I'm sorry your string site was too good. You spent all that work making it too good and too convincing that it got cut. I feel you. I've been there. I'm sorry.
Well, he did get footnote 1, right? So it's a pretty prominent shout out. It's kind of funny to the tone issue. Yeah, of course, the tone of this is acerbic throughout, with a lot of little jabs here and there. But it is funny to say something like that, to say like, well, I had my clerk pull a list together, but it would have embarrassed you so badly that I'm not even including it. And so you're kind of like, at this point, you should have thrown it in as an appendix to see if it's really as withering as you suggest it is, because it feels like you proved too much with just the footnote saying it would have been so bad that you would have felt like a criminal being shamed with this rap sheet.
I forget the name of that. The director of our Center for Judicial Engagement, Anthony Sanders, knows a lot about the classical world and classical rhetoric. There's a specific name in Greek or something for the device that's like, I'm not even going to mention this thing that I'm totally mentioning by saying I'm not going to mention it, but it's bad. Just trust me. Yeah,
so to the substance of Andrew's disagreement with me, I think the reason that Judge Van Dyke is able to use this as, the example, and then he gets very hyperbolic with how terrible it is that you do have the situation where the panel came out the other way on these issues and then was, in one way or another forced to sort of retract that opinion and replace it with this one, but then leave in that same analysis just as even if we did it the other way, we would say this. And so you have the dissenting judge on the panel in both instances pointing this out. And he even says, I think, in less of a direct tone than Judge Van Dyke here, that the panel's decision to leave in that dicta was less than noble, I think is the phrase he uses, which is obviously, much more of the sort of historically formal and forgiving tone that we see judges use with one another usually.
Yeah, this whole binding dicta reminded me, I think the real question is at what point does something like this really get into being an advisory opinion? And I think that Judge Van Dyke kind of got into a little bit of that in his dissent, but didn't fully get there. But it's a fascinating decision, and I'm sure we'll see more of Judge Van Dyke sparring with his colleagues over the years.
I actually wonder, if his response to this will be like, okay, well, I'll start adding well-reasoned dicta to my opinions and see how you guys like it. Because one of the main rhetorical points that he makes in the dissent is that he points out that the author of this panel opinion has himself refused to follow dicta that others have called well-reasoned by just saying, well, that dicta is not well-reasoned, so it shouldn't be followed.
Patrick's projection for the future is much cleverer than mine. I just assumed they'd be just really contentious at the next, Ninth Circuit picnic or something where they'll get together.
That seems like a safe bet. See how many cookie jars are being passed around at that picnic.
Well, thanks, Patrick and Andrew, and thanks for all of you for listening. We'll be back next week, and until then, I ask all of you to get engaged.